welcome to Making the Case. I'm Nayyera Haq, in for Yodit. We begin tonight in Brooklyn City, Minnesota, where today the jury in the trial of Kim Potter heard testimony from 3 more prosecution witnesses. Potter, a former police officer, is charged with first and second-degree manslaughter for killing 20-year-old Daunte Wright during a traffic stop back in April. She claims she grabbed a gun by mistake. You can hear her on body cam video yelling, "Taser, taser, taser," before shooting. Here to help us unpack day 8 of this trial is my panel of lawyers, veteran prosecutor and BNC legal contributor Paul Henderson and criminal defense attorney Brian Watkins. Gentlemen, let's get right into what we learned today and why it matters. Brian, I'll start with you. The prosecution began with the testimony of Major Michael Johnson. He's Potter's supervisor on the day of the shooting. They questioned him about why he took her gun and then gave Potter his. Take a listen.
Her mental state of not knowing what she might do. I knew that her firearm was a piece of evidence at that time, so I removed her firearm and put it in my holster and put my gun in her holster, just so that evidence was preserved.
And before he switched the guns, Potter asked him to, quote, "Just let me kill myself," end quote. Now, his gun had no ammo. This shows that there was real-time remorse. So, Brian, how does that real-time remorse help the defense?
It helps the defense immensely. I mean, clearly they're going to be arguing that this was an accident, and that clearly corroborates the fact that this was, in fact, a tragic accident. Her reaction immediately thereafter is not staged. It's not something that she's doing for the court. It's not something that she did at a press conference. It happened immediately without provocation and got all caught on camera. So I think that's going to help her case a lot. However, this witness in and of itself, he did come to her aid, even though he was a prosecution witness, because he basically testified that even if she did shoot him on purpose, it would have been justified based on his actions.
Paul, your reaction to the body cam footage that we saw from Major Johnson. It shows him calling the dispatch for additional units because there's a shooting, but he never mentioned that it was an officer-involved shooting. Take a listen to this.
305, we got shots fired. Start more units, please. We're going to need additional units to Noble and 63rd.
Paul, this comes after yesterday's testimony in which prosecutors tried to prove that the officers who arrived at the scene were in the dark because they were not told it was an officer-involved shooting. So is that an important detail?
It is an important detail because it shows that the officers around her were protecting her, that they weren't informing their audience of what happened, and that's the information that they needed. They were trying to protect her and to help her, and that's why they were testifying almost in her defense and almost needed to be treated as a hostile witness because the information that they were giving to the jury and giving to the audience was about how they thought that it could have been a justified shooting. The real issue, though, and this is the prosecution's challenge, is to be talking about the case and make the jury understand that even if it was an accident, some accidents have legal consequences, criminal conduct. And so if your accident was reckless, let's say you're driving 100 miles per hour and your car goes out of control. You could say it was an accident, but you were driving 100 miles per hour. So if you are engaged in lethal activities, your standard of care is higher. And in this case, it's more clear because this was the trainer, the person that actually had received 26 years of training and was training. So her accident is qualified as a crime. That's prosecution's role, to unpack and explain to the jury. And these witnesses that are with them, that they are putting on the stand, are still dancing around and trying to diminish the accountability for their friend and for their peer, which, by the way, just recollection is opposite of what we saw with George Floyd, which happened at that same location, where they had law enforcement testifying clearly about how inappropriate it was, how outside of the realm of training the behavior was. And we're not seeing that coming in this case from the prosecution.
Yeah, Paul, you mentioned the Chauvin trial in which really none of his colleagues were coming to his defense. Brian, how is this different then, given that this is a prosecution case?
Well, there can be, those cops are friends. They work together. They've been on the beat together. They saw what happened. I mean, they don't feel that she did something wrong, that it was a mistake that could have happened to anyone. They've been in stressful situations. They may have reached for their gun and thought, and caught themselves before they got their taser. So they can relate to her. And it's going to be easy for them to be empathetic and basically, tell the versions from their side, which is the side where we're dealing with someone who's trying to flee the scene, who could be combative, who could try to hurt us. We're trying to, basically just enforce the law here, and we're often victims of that. And they see it from her perspective. And I think that's what's going to come out on the witness stand. When you put these cops up on the stand and you question them, that's what's going to come out. That's what you're going to get. But the prosecution's stuck with that because those were the individuals that were at the scene. You got to call your precipient witnesses. There's no way around it.
Yeah, interesting, as you mentioned, that they're called as prosecution witnesses, but they may have actually helped the defense's case with this empathy argument. And Paul, I want to bring in the idea of who was getting empathy in this situation. If you look at the Daunte Wright quote, he's the victim here. And there's mentions that he kept resisting and asked him if Potter legally had the right to use deadly force. What is up with that line of questioning?
Okay, well, that line of questioning raises the issue that prosecution has to rebut, and they need to come back and explain to the jury that you don't get to address the danger that you created. That's the issue. So they're going to be arguing that later on. Like I said, they're stuck with the testimony that they get from the officers that are still trying to help her and are very sympathetic to their peer, whom they feel just had an accident. But the reality of it is, Daunte Wright is still dead. Daunte Wright should not have been killed, and he was killed because of the subjective decisions that the officer made that escalated the encounter from having something hanging on the windshield, the wiper, the air freshener, and this escalated into someone being killed. That decision right there is a problem. That decision has consequences. Before you even start talking about reaching for the gun instead of the taser and why all the reasons that shouldn't have happened, but that's a compounded accident that leads the prosecution to be arguing that this is actually a murder, that this is, even if it was an accident that should not have happened and should have criminal consequences with a guilty verdict. That's what they've got to argue.
And that's the defense's argument. But as we were talking about just a moment ago, the prosecution witnesses that we saw today and heard today also may have helped the defense argument. So what next, Brian, for the prosecution? How do they move forward after today's testimony?
It's going to be tough because they put on that officer who was well trained, who basically told this jury that even if it wasn't an accident, she would be justified in shooting him based on his resistance and the circumstances that were presented. So now they have it two ways. They basically hedged their bet. So even if you don't find that it's an accident and she did do it on purpose, that's still okay too, because it was justified because of his level of resistance. Clearly getting into a car, starting the vehicle and starting a high-speed chase, possibly running down officers. Deadly force has been used many times in those situations, and it's all been ruled justified. So now they have basically the double whammy. The defense has a double whammy to say, even if you find that it wasn't an accident, she was okay to use deadly force. So either way you slice it, she's not guilty. So the prosecution's in a bad situation right here.
Paul, Brian, stick with me right here because we're going to come back after the break. And I want to get your broader takeaways, not just from today's testimonies, but also the cultural and emotional impact of this week of the Potter trial. We'll be right back. Welcome back to Making the Case. We're continuing to break down day 8 of the Kim Potter trial in Brooklyn Center, Minnesota. Back with me is veteran prosecutor, BNC legal contributor Paul Henderson, and also criminal defense attorney Brian Watkins. Paul, I want to start with you on this because I'm going to level here as a mom. My son very easily could grow up to look exactly like Daunte Wright. And I remember that moment when that video first surfaced and we first heard about him being killed. And it all starts with a traffic stop. Give us the context an understanding of why traffic stops like that are so problematic for Black boys.
Well, they're problematic in jurisdictions that don't have reformed use of force policy. That's a real issue. And just as a reminder, 2/3 of all law enforcement agencies in this country, and that there's over 17,000 of them, don't have use of force policies that have been reformed, which means the policies that they're following for escalating force and escalating encounters with anyone with suspects means that by adoptive admission without the reforms, they are still doing things like shooting at cars. They're still doing things like using carotid techniques on the neck, which where you restrain the neck. They're still doing things like executing no-knock warrants, where we've seen cases in the headlines that have been proven to be not best practices and safe both for suspects and for law enforcement as well. And this is another one of those jurisdictions where any encounter at all can escalate. There's no policy there, and they don't have the training addressing de-escalation. They don't have the time, space, and distance, which are the three factors when you're encountering dangers, to try and address the situation to make sure that everyone comes out of it alive. And here's the thing that I keep reminding folks, that if you have committed a crime, the cops still should not kill you, even if you are guilty. That's what we have juries for. That's what we have judges for. That's what we have prosecutors for. And so when we are having this discussion again, and I'm getting tired of having the same conversation with different facts over and over again. And this is before we start unpacking the race disparate outcomes of encounters with communities of color and law enforcement. But all of that falls to the wayside when we start examining what the role of law enforcement is supposed to be when we have encounters like this, and with other things like homelessness or mental illness or substance. They should not end in death. They should not end in encounters where lethal force is used, and that's the problem. This is an air freshener that was on a rear view mirror, and someone ended up dying, and they had all of his information. He was compliant, had turned over his records, and they could have issued him a warrant. They could have gone to his house to arrest him. They could have given him a ticket, but instead he's dead. That's at the heart of this conversation, and that's why it matters to so many people beyond just this verdict in this case.
Well, and Paul, they could not stop him for an air freshener violation, right? There are plenty of ways that other jurisdictions also deal with potential traffic violations, which, as you said, usually don't require a death sentence. Brian, Paul just mentioned the lack of training, right? And the use of force challenges we have here. Help us recap what we know so far about Kim Potter's training with the taser and with the handgun.
You know, she received the standard police training using the taser and using the handgun. But this is what we have to understand here. I do civil rights cases. I've tried many cases, police excessive force cases, wrongful death cases. And I'll tell you what all my clients, who are the mothers of the decedents, will tell you. They wish that their son did not resist. We have to learn to respect the police and obey their commands. And if they wrongfully arrest you, you call my office and we'll sue for wrongful arrest. I don't want to have to sue for wrongful death. And that's a problem. The truth of the matter is, there is no amount of training or protest that will ever make it so that you can physically and violently resist the police and your safety will be guaranteed. That is never going to happen. And if that's the goal, it's never going to happen. So we need to teach our children that, yes, the police have control of the situation, you obey their orders, and then you get a lawyer and you go to court. But you do not resist. You do not try to run away because you can be shot. It's scary to officers and they will shoot you. Regardless of whether the officer is punished or not, you're still dead.
Well, that's right, the conversation that we've had generation after generation. And, we were told that by the time it came to my kids, all of these problems would be solved. We wouldn't need to have that conversation. So at what point, Paul, does it become about fixing the system and not fixing the conversation?
You're asking the right question, and generally, here's how it works. There are three separate tracks of accountability. There's the criminal accountability, like the trial that we're talking about right now. There's the civil accountability, like the cases that we were just talking about with the lawsuits where people get settlements and you sue someone, you sue the departments and you sue the city. And then that third track is the administrative accountability. And that's the most important and crucial part that we're talking about right now, where the chief of police can institute policies reflecting best practices, where communities, mayors, community activists can demand that policies be reformed to use of force to address some of these subjective and intransigent decisions with race disparate outcomes involving use of force. That's where the meat hits the bone, and that's where we have to focus on in terms of moving forward. And addressing the other two is not going to address the third challenge of coming up with policies tied to training to make sure outcomes are better, reformed, modern, and reflective of best practices, and a race-neutral definition for public safety. That's where we have to have conversations on just waiting for the federal government to give us the George Floyd bill, which they should. Beyond just waiting for our governors and state legislators to give us laws mandating the policies. We can start those reforms right here, right now, today at the local level by talking to our mayors, by talking to our chiefs of police and demanding to see what is our use of force policy? What are our race data that are being collected? Is that transparent? Is it being analyzed? Are there civilian oversight agencies in this jurisdiction? How do we start one? Where do we go from here? We are empowered with this knowledge because of conversations like this to go out tomorrow and start making a difference. So we're not just waiting for the next headline, and they are coming, that shows us that we have to do something and take action. We cannot sit by and wait and vote. We need to do those things too, but we can all empower ourselves with activism and knowledge to be making demands at a local level to start the reform today.
I'm so glad you mentioned the local aspect of this, because every jurisdiction is different. And there's police accountability review boards in different counties. There's also the fact that many police departments don't report data up to the federal government, to the point where now the FBI is thinking of shutting down its entire reporting database because they just don't have enough information to make national trends. But I want to get back to, Brian, with you, the courtroom. What was really happening in the courtroom? We've talked about the system and the broader trends, but in that courtroom, there was a moment today where there was emotion, right? And the emotion expressed by the person who's in the defense chair right now, Kim Potter, that she, a pool camera reporter mentioned that, she put her head in her hands and, she was shaking and she was crying. What does that emotion do to a jury? And does that get counteracted at all by the emotion that we heard earlier in the week by a girlfriend, by Daunte Wright's mother? Like, what's the role emotion is playing in this trial?
Jurors are human beings, and emotions affect all of us. And it really, what it goes to, it really bolsters her credibility. Is she truly sorry? I mean, we have to look at this case. What's the narrative here? Either it was an accident, an innocent mistake, or it wasn't. And if you say it wasn't, you're saying that she deliberately wanted to murder that child. That's a tough thing to prove and to show to a jury. Why would she want to kill that child purposely? I mean, and so that's a tough question to ask. And then when you see her emotion, it goes to, well, she probably didn't purposely want to kill him. She probably did it by accident. So this is the testimony that's being brought to the jury without there actually being testimony of that, because they're looking at and seeing the emotions of the defendant, and they're going to judge whether or not it's genuine or not.
Yeah, and Brian, as you mentioned, that the idea of someone being sorry doesn't mean that there's no accountability, hence the varying charges between murder and manslaughter, et cetera. But we will make sure that you both keep our viewers up to date on what's going on in this trial. Thank you for joining me tonight, Brian and Paul.